Hi, everyone. Hope you're well, wherever you're listening from, whatever you're watching from. I am with Jane from Umbrella Law today, and Jane is a family lawyer. Jane, can you please tell us why you joined Umbrella, or why you started Umbrella Family Law, and why family law?
Why family law? Because I genuinely care about helping people. It sounds a bit cliched, but it's true. It's really such a privilege to be able to help people through a really difficult time in their lives and something that's hugely pivotal, and to be able to navigate that through with them in a way that is going to mean that they're okay at the other end, emotionally, practically, financially, and legally as well. And we started Umbrella Family Law in 2018, my business partner Eve and I, because we wanted to bring our heart and soul and do family law a little bit differently. We have a very holistic approach to caring about our clients, and I always say to people that at Umbrella we've got lawyers with great hearts who are also damn good at their job, and that makes for a good combination.
Amazing. Because family law is a very sensitive area, isn't it? It's very emotional. I mean, commercial law can be emotional too, but more so with family law. Because you've
Well,
got
absolutely, because I guess there's nothing more fundamental. I mean, your health is fundamental, but next to that, your family, your spouse, your kids, pretty damn important factors in your life. So really family law it's really a life problem and an emotional problem for which there's a legal consequence rather than just being a legal problem.
Yep.
The legal aspect, yes, it helps you to get to a binding position, but it's really the disentangling and rebuilding of a life. So it's massive stuff.
Yeah, 100%. Could you tell me perhaps an example with that, leaving out too much of the detail, as something you recently helped out with, and what was the result? What was the background and what was the result? And obviously the emotional aspect of it, just to give us a real taste of what family law is like.
For sure. I guess I've had a bit of a run lately of men with exes who've got some concerns, sometimes genuine and sometimes not, about their capacity for those blokes to spend time with their children after they've separated. So I've been acting for kind of 3 or 4 dads who initially the mum has said, no, you can't spend time with our children now that we've separated. And I've had one of those in particular. It's been a really beautiful journey, and we moved through. He spent some time initially having his time supervised by a professional supervisor, and then moved on to having unsupervised time with his kids, which of course anyone would expect that they would do. But for this guy, his ex made him jump through some hoops. And he sent me some photos of the time that he spent with his kids over Christmas, and it was just so beautiful to see that relationship rekindled, reignited, and the joy on the children's faces at the dad's face. And of course, money is important, but when you can help make a difference in people's lives in terms of ensuring the smooth running of the time that each parent is spending with their kids, that really touches the heartstrings, and that feels really valuable.
100%, especially during a season like Christmas, where families are supposed to be together. So it's always helpful, obviously, to navigate those tricky areas. I'd like to ask you a question regarding when the court would deem people to be in a partnership.
Okay, so technically, obviously, if they're married, then that's a tick.
Yep.
And otherwise, in terms of when the family law comes into play, technically in de facto relationships, it's when people have been living together for 2 years. But anybody who's had anything to do with the family law system will know that it's incredibly grey. So there's also an exception to that, which is really if the partners have got assets that are entangled, then that's going to be relevant before the 2-year period. If one of them has made significant financial contributions to the relationship, that's going to be relevant before the 2 years. And of course, if they've got children together, that's another very relevant factor that might then mean the court steps in and has some jurisdiction. And I guess without jumping ahead in our questions, Mina, that's often a reason why people might consider entering into what's called a prenuptial agreement, a cohabitation agreement, a binding financial agreement, to look at protecting their assets. Because if you're entering into a relationship or a marriage with assets that are of value, or it might be that you've got a loan to parents, or that you've received an inheritance or gifts of money from family, or you're a business owner who's built up a massive asset over a long period of time and you want to protect it, it's worth entering into an agreement, certainly if you're de facto, even before that 2-year period, just to absolutely ensure that you're protected against any possible claims.
Jane, at Pinnacle Accounting and Advisory, we try to help business owners as much as we possibly can. So we focus on business tax, investment tax, and actually growing businesses too, forecasting, budgeting, planning, advisory sessions, that type of thing. So really, business owners are a big part of the area, the group that we focus on. So what are some handy tips you can mention to them that will help them on the journey, things to remember as they go into a relationship with someone?
Sure. I guess tip number 1 is to consider getting advice from you, and potentially from a financial planner and from a family lawyer early on in the piece if they're going to start living with somebody, or if they're looking at moving in with somebody post-marriage, to consider what the likely impact might be if they didn't have an agreement to protect their assets, so that they can have an understanding of the way things might work from a family law perspective. And we'll no doubt talk about that, you and I, shortly, in terms of the way the law works in dividing assets.
Yeah.
And I do think it's really important if they're putting their heart and soul into a business or if they're coming into it with money to really look at considering putting an agreement in place.
Look, sadly, sometimes people focus way too much on business to the degree that they don't have any time for family. And depending on the partner that you have, some partners understand that. They understand that you're working for family. You're treating them right. Sometimes, though, it can be a bit abusive. Sometimes there's other various things happening in the home, right? Abuse is not just on a physical level. It can be also on a mental and psychological level from either partners, right? So again, what are some things people should be bearing in mind when they enter into a relationship? How does a binding prenuptial agreement work? What does it cover? Does it cover assets going into a relationship or assets during a relationship? How does it work exactly? Please
it can cover both. It might be good to perhaps pull back and look at what the world would be if somebody enters into a relationship or gets married without an agreement in place. And essentially, when we look at the way that assets would be divided from a family law perspective, whether it's de facto or marriage, it's the same law. There are four main steps that we look at. The first of all is we look at what's in the asset pool, and that's anything that's beneficially owned by either of the parties or jointly. We secondly look at, and so that would include, of course, an interest in a business, plus real estate, cash, shares, et cetera, et cetera. The second thing we look at is how those assets got there. So we look at what the line in the sand was and what assets each of the parties had at the time that they started living together. And then we look at what came in during the relationship, not by way of income, but by way of gifts, inheritances, transport accident payments, work cover payments, redundancy payments, lump sum contributions in particular. Thirdly, we look at current circumstances and future needs in terms of at the time that the parties have separated, what's their age, state of health, income and earning capacity, what level of care of children do they have? And fourthly, there's a sense then of looking at overall fairness. So what that would mean is that if somebody has brought in a business that might be of some value, or it might be that in addition to their business, they also have real estate, say, that's a common one, particularly in second relationships or people getting into partnerships later in life. What that means is that at the time that they separate, we look at what the value of the asset was at the time they started living together and look at what that is as a percentage of the asset pool at the time that they're separating. Somebody once described this to me as like the chocolate milkshake argument, where your asset at the time that you started living together is your chocolate syrup and the years are the milk, right? So if you've been together a long time before you separate, then there's a heck of a lot of milk in your syrup. So whereas at the beginning of your relationship, you may have been bringing in an asset that was of significant value in the course of your asset pool, if you've been together a long time, the impact that will have in the way that you divide your property is going to be reduced. The benefit of a cohabitation agreement, prenuptial agreement, financial agreement, whatever you might call it, that looks at providing for what would happen now in the event that you separate, the benefit of that is that you can say, well, actually, I want to get either the full percentage value back, or I want to get the physical value back. If I've got a property worth 500,000 at the beginning, I want 500,000 back. There are various ways that you can go about it, that you're actually protecting what you're bringing into the relationship. And also, it might also be that you know that your business is maybe you're in its infancy now, but you know that it's going to be worth millions and that you're the one that's going to be putting the heart and soul into it. In theory, you can provide in these agreements that the business would be yours in the event of separation. Or you can look at, perhaps it's a percentage or it's a dollar figure or whatever it might be for your partner, but that would be much more in your favour than what would flow if just the legal process was followed when you separated.
Would that be the same if, say, the husband or the wife is the sole breadwinner, income earner of the house, of the household?
So I guess there's a couple of things there. One is that, and I know you're talking about business owners, but if, for example, somebody has just been, well, from whatever source, if there's one person that's been bringing in the income, that's not seen as a contribution over and above. So there's a general sort of weighing of the monetary and non-monetary contributions. And in day-to-day terms, even if you were married to Bill Gates in Australia, he's not going to get an advantage in his favour because he was earning lots of multi-millions of dollars and somebody was staying at home with the kids. I don't know what Bill and Melinda did. Maybe it's a bad example, but hypothetically, right? So the theory is that the law doesn't disadvantage the person who's been the homemaker in terms of day-to-day income. And in fact, quite the contrary, if there's a discrepancy in income and earning capacity at the time of separation and you don't have a financial agreement, and this often stings a lot of people who have been the primary income earner, if somebody earns 100,000 and somebody's been stay-at-home, then there's going to be an adjustment in the property settlement for the person who has the lesser income and earning capacity.
Reflecting all the labour and everything they brought into, obviously, the relationship.
And in theory, because the person who's got the greater income can go out and will recover faster post-separation than the person without the income.
Okay, that's a good angle to look at it from too. Understand.
Can I say, the reality of that is that neither party typically feels that works for them. the person who doesn't have a great level of income still feels like they won't have enough money. And the person who's been bringing in the income feels like they're getting ripped off because they've been working hard and they're being penalised. And this is why it's really great to consider looking at an agreement before you enter into the relationship or during the course of the relationship as well. It doesn't have to be just before the relationship starts. It can be while you're together, but before you separate, because then you can really take into account kind of the reality of your situation and not just the very narrow view that the law imposes.
So I'm understanding that there is a prenuptial agreement before entering into the relationship, and there's a binding financial agreement at the end of a relationship. Is there a different agreement that operates throughout the life, the period of the relationship?
It's a different section number, but technically they're all binding financial agreements. It's just that one is entered into before the relationship or the marriage, one is entered into during the course of a relationship or during the course of the marriage, and one is entered into at the end. But they all do the same thing. It's just that the ones that are entered into before separation, it's very much a crystal ball element of looking at what might happen if separation occurs. Whereas if you're doing it after you've separated, you obviously have your line in the sand and you know what there is that you're dividing and you know what people's circumstances are at that time.
Yes. Now, you gave us an example before about how you helped a husband out or an ex in their relationship in terms of seeing their children. How does child support work, and what are some factors that someone would need to show to prove that they are able to look after their children and therefore the courts will grant access?
Okay, so I guess there's two questions there. So one is around the concept of the time that people are spending with children, and the other is the concept of child support or financial support for children. So to start off with looking at time with children, not in relation to finances, but just in relation to kids themselves. The law is changing, but in general terms, it's a question of considering what has been the past in terms of what's the relationship that both of the parents have with the children, and what is the capacity of those parents moving forward to provide for the day-to-day care of the children, and what's the bond like, what's the relationship like between the children and the parents. The overarching factor is always what's going to be in the best interest of the child. So what we sometimes see in situations where, perhaps sometimes a marriage breaks down because one person has worked super hard, crazy long hours, and has hardly ever been there for the kids. If that person is going to continue to work crazy long hours and will hardly ever be around, and the kids would always be in before or after school care or with grandparents or whatever, then in that circumstance, it's not likely that they would necessarily have large slabs of weekday time with the children if the other parent is available to pick them up from school, run them to the extracurricular activities, and kind of be there. But if you're looking at, sometimes for business owners, having an own business can be a massive advantage, because in theory, it can mean that you can be a little bit more flexible with your time. So even if that person has sometimes chosen to not be flexible with their time during the relationship, sometimes we find that at the end of it, you know what, actually, I can shuffle things around so that I can pick the kids up. I would like to have them for a bit more time, which often annoys the other parent no end, because they're like, well, if you'd done that in the beginning, we would be still together. But the reality is that it's about being available and accessible to your children, and about the relationship that you've got with them. Because it might be that you can say, well, I'm around all the time. But if the kids, for whatever reason, are fearful of the parent or just more closely bonded to the other parent, then there's no general rule of thumb in terms of the way that these things work. There was an assumption some years ago that dads used to think, I'm entitled to equal time. There's no such thing as entitled to anything. It's always about what's important for those children, what's going to be in their best interest.
The court will judge based on the merits.
Yeah, and I mean, the reality is that the court is a place of last resort, we would see. And when we're looking at helping people with these issues, we will often refer the couple to talk to a child psychologist to work out what's actually important in the nuances of their family. There are a lot of kids these days who may be on the spectrum and have additional needs, and those things obviously should be taken into account. And so therefore the needs of children in that family, or one child that might have additional needs in a particular family, will be very different to the needs of a child or children in a different family. And that's where, again, the law provides a framework, but ultimately reasonable parents thinking about what's going to be good for their children will not necessarily need to fall back on the court. But the social sciences and the idea of bringing a psychologist in, for example, to really talk in a calm way about what's going to work on a practical level for our family. Are you really able to get there to pick her up from netball? Can you really take him to the Saturday morning swimming lesson, et cetera, et cetera? That's a much more sensible way, I think, to try to discuss time that you would spend with children.
Here's a question that just came to mind. Yes?
Yes, go.
No, I don't want to interrupt you. Finish your train of thought.
Go ask your question, because I was going to start on child support. So shoot, Minna.
Okay. What about grandparents? Say the business owner
Great question.
isn't able to look after their kids, right? They're not able to see them as often. But what about the grandparents? Do grandparents of the party that can't see or can't commit to their child, does that mean that they won't be able to see their grandkids? Because obviously, you know how grandparents are about their grandkids, right? They love them a lot more than they love their own kids.
They often do, yes. So a couple of things, I guess. The starting point typically is to consider that grandparents can see their grandchildren when their child sees the children. So in other words, if your parents of dad, then when dad sees the kids, grandparents can see the kids. But that said, separate to that, grandparents do have their own rights also to have a relationship with their children, with their grandchildren. So if the parent in the middle is not going to facilitate the relationship between the grandparents and the children, they absolutely have the right to say, hang on a minute, I really want to spend time with my grandkids. And sometimes a business owner might think, well, actually, I'm not available to pick up from school, but mum and dad can do it. And so that's that grandparental time. Sometimes that will wash, but sometimes it's still seen that if actually the other biological parent is available to do it, it's more important that they're spending time with that parent than necessarily regular time with the grandparent.
What if
Again,
the
you
other
see, this is
party,
where family law is grey.
what if the other party doesn't want the grandparents to see the kid for no reason? So the grandparents were
Yeah.
absolutely fine with the kid. They love each other. But again, because say the husband or the wife, they're no longer on good terms, it's automatically now, well, my enemy, and that almost by default makes their family my enemy. Not always the
Great
case,
question.
but it depends
So
on who we're dealing with. Yes.
If need be, the grandparents can become part of family law proceedings and seek their own orders, or it might be that the party whose parents are in dispute seeks as part of their orders that there is provision for their parents to be in the same space as the children. You know, if somebody's saying they want an order restraining grandparents from being around, then that can be opposed by the grandparents and by their child to say, actually, there's no evidence about this. There should not be an order that prevents us from being around the grandchildren at the same time as our child is around them. But separately and over and above that, you know, sometimes if grandparents have been very involved in children's lives before separation, it's not going to be enough that they're just seeing the grandkids when the parent sees them. So that's where they can come in and say, actually, we want some time over and above that. And again, this is where it's great if that work is being done in mediation or with a child psychologist, where all of the nuances can be taken into account rather than necessarily being dealt with by the court. But the court does have provision to deal with it.
Okay, there's quite a lot there. We need to digest.
There's a lot everywhere.
Information.
It's such a
Yes.
complicated area.
Yeah, it really is. Yeah. Can we move on to child support and how that would work?
Yes. So in the first instance, child support is based on a formula that's put in place by the Child Support Agency, which is now Services Australia, which is based on looking at the number of nights that each parent has with the children and looking at the respective incomes of the parents. That works with income up to around the sort of 150 mark, and I'm not sure exactly the current cutoff, but for higher income earners, typically what we see is that there would be negotiated a private binding child support agreement, pursuant to which they would pay a regular periodic sum, typically fortnightly, a sum to the other parent. And in addition to that, they would pay some or all of things like school fees, extracurricular activities, private health insurance, out-of-pocket medicals, etc. So, because the reality is that the assessed amount for child support is really very small. And it's very hard for people really to get by and to pay all of the expenses that are needed if the paying parent is just paying what they're assessed to pay. And that is often what commonly happens, as I said, with lower income earners, but with higher income earners, typically there is that arrangement that provides for additional expenses to be paid over and above the very baseline child support. So if you're a business owner, the other thing that we often find is that business owners, of course, are able to manipulate their income often. Heaven forbid, Minna, right? Heaven forbid that would happen. But if they do, you know, child support is in the first instance is based on taxable income. So if your taxable income is low, then your starting point assessment is going to be low. But often what we find then is that the partners of people who are in business and hiding their income will go to great lengths to have the child support agency try to get to the bottom of what is the actual income. Or sometimes those business owners will also negotiate kind of based on a notional income and sort of hedging their bets around, well, let's say I'm going to pluck it and pay a figure that's going to be based on me earning X amount. And if I earn more, that's good for me and I might choose to pay more. And if I earn less, well, that's my bad. I need to still pay whatever figure we've locked in. So the short kind of summary is starting point is child support agency assessment. Over and above a kind of a higher income earner, you're looking at probably a periodic amount plus some or all of those additional expenses for the kids.
So what was the threshold again? Sorry.
Well, that's the shortened version. So the child support agency assessment is the starting point.
Yes.
To a certain point, but then with higher income, it's usually a periodic amount plus those other expenses.
You mentioned or alluded to planning around that area. The question I have for you, we're going to get creative here as advisors, right? But this is an area that is a sensitive area and we have to show compassion around it too. But the question I do have is that assessment, is that performed at an individual level or is that performed at
it's based
what
on
the person
taxable
can,
income.
Taxable income of the individual?
Yes.
So if they have, say, something like a company that can issue out dividends and they don't issue out dividends, then technically they don't have a high enough
So that's a
taxable
circumstance in which the other parent might make an application to the child support agency or through the courts to look at what the actual earning capacity of the other parent is. So yes, you can try to manipulate things, but I mean, my advice would always be not to do that. And ultimately, there are lengths that can be gone to by the parent to whom the money is owed to try to get to the bottom and kind of lift the veil and see what's really going on.
So some key points here is that the courts or the legal system can look at the earning capacity of a particular person or the companies that they are responsible for. I guess that will be further complicated where the companies or the trusts have other directors or other parties, right? That will reduce their ability to really call the shots or make an arrangement where they can pay themselves more.
Yes, and this is where, of course, people need to get individual advice from their accountant and or their own family lawyer at the point of separating, or if they're considering separating. And that's the other thing, is that sometimes people will know that things are not going particularly well in their relationship, and they come to us at an early stage and get advice before they even tell their spouse that they're separating, so that they can start to plan for understanding what the outcome might be and whether there are things that they can do a little bit differently to improve things for themselves.
And ideally, Jane, the best position to get at is a win-win position, because at the end of the day,
absolutely,
you don't want another party to be hurt, because that can just, we know karma can come back at you. Right.
Completely. And when it comes to child support, I mean, ultimately, what you wanting to do is ensure that your kids have a nice life.
Yes.
So it's a question of, the parents might have different ways about the way that they want to go about that, but ultimately it's the children who will be benefiting from the child support arrangement.
Yes. So I'm not saying really to either of our clients, don't be strategic about things, but also look long-term, right?
Absolutely.
Make sure you're looking to achieve win-win. It's not about the parties hurting each other. It's about recognizing, okay, well, maybe we were good together for a period of time, right? But for whatever reasons, things aren't working out. For me personally, just so you know, I'm pretty old school, right? I would like to see as little people as possible get divorced. I personally don't believe that divorce should be an option, that parties should work it together. But at the end of the day, we're looking at what our options are, what the situation is, and allowing for an understanding that this can no longer happen, or this is not really working out, and we need a solution for it.
Absolutely. Absolutely.
Yeah. Okay. Fantastic. Thank you for covering those points. Can you touch up on wills? I know you focus more on family law.
Yes.
But is there, in relation to wills, is there something the party should be keeping in mind?
I guess the bottom line there is that you should have one. It's always better to have a will than not to have a will. And that will, in my view, should be done by a solicitor, particularly if you're a business owner and there's some complexities to your asset situation. You should definitely see a lawyer to make your will. You need to give thought to, I guess, whether you're providing for everybody in your life, because there are provisions for people to challenge wills, of course, if they feel that there's somebody that should have been provided for that wasn't. For example, if you've got 3 children and you decide to only provide for 2, there need to be a sense of why it is that you're not providing for the third one, for example. People often will make wills in contemplation of marriage. Again, it's because marriage often, I think, invalidates a will, but again, you need to
my understanding is it does.
Yeah.
We need to draft
so sometimes I know that it's possible, though, to make a will in contemplation of marriage, so taking into account that this is coming up. You also want to make one after you separate, because you don't necessarily want to provide for your spouse. So commonly, of course, we'll provide that everything goes to the spouse in the first instance, and then in the event of death of the spouse first, it goes to the children, etc. So it's very common post-separation that you would want to think about making the new will to provide for your new circumstances. The short answer in the subject of wills, Minna, is get one and discuss it with an expert.
Fantastic. Great summary. What about the assets? What assets will the courts or the legal system look at in terms of separation, or when people are entering into a marriage? I know separation is not.
As I said at the beginning, essentially the court looks at any of the assets that are beneficially owned by either of the parties or both of the parties in joint names. So interest in a business, they look at a trust when they look at who's ultimately responsible for the trust. So if particularly, for example, the person is appointor of the trust and has ultimate control of it, as well as being a beneficiary, etc., that's going to be taken into account as an asset. In terms of assets of the business, again, it depends on what the shareholding is of the business, but the shareholding of the spouse in relation to the business, even if it's been filtered through kind of multiple channels, but ultimately the beneficial interest of either of the spouses in a business or trust will be taken into account. It's really difficult, and of course I would advise against it, but it's difficult really to structure your assets in such a way that they're not going to form part of your matrimonial asset pool, unless you have an agreement that you're entering into by way of your financial agreement that says this will not be taken into account when we separate.
Are you still considered under control of a trust where you are the a second appointer?
If you're the second appointor, interestingly, most trusts we see have only one appointor. But ultimately, if you have control of the trust, and or if you're a beneficiary and there's a regular pattern of you receiving dividends from the trust, that it's going to be taken into account. Distributions from the trust, but it's going to be taken into account.
That's a great point.
And again, it all comes back to disclaimer. You need individual advice about your circumstances.
Yes.
But
yes.
the bottom line is, if you know that an asset is yours, it's ultimately going to be found to be yours.
Yeah. Just
That's
to make
the
it
bottom line, really.
a little bit more complex, what if through the distributions it was given to an investment company instead of the actual person receiving the funds?
Well, again, I suppose it depends on who's ultimately receiving the benefit of the distribution company.
Yes.
As I said, really, the bottom line is, if you know that it's yours, it will ultimately be found to be yours.
Yeah. I think throughout this conversation, our viewers can appreciate how complex this area is, especially for business owners, where you've got multiple entities, you've got a large structure which you are using to make strategic investments. You need to really have a look at that. You need to speak to the right people, your legal team, from a family law perspective, from wills perspective, commercial perspective, and the accountant, financial planner, to make sure that you understand what you're able to do and what you need to do if things go wrong. Wrong. Now, I want to change for a second to the tax implications of a breakdown, because I had a client reach out to me sometime, actually about a week ago, saying to me, Mina, there's an issue where I'm getting a divorce. The assets, I'm selling the house. So what's going to happen with the capital gains? I'm going to hand it over to you to explain at a high level what tends to happen with the tax aspects, and I am going to contribute to that conversation, that topic as well.
Fantastic, because really that's more your area than mine. But very high level, when there's a breakdown of a relationship, there's what we call capital gains tax rollover relief between spouses, which is that if you're transferring your interest to your spouse, that's not something that's going to attract capital gains tax. But what we then look at is the fact that the person who is left with the asset may ultimately have to pay capital gains tax down the track.
Correct.
And typically the way that the law deals with that is to say, well, if you're about to sell the asset, and usually that's if the couple jointly decide to sell it as part of their separation, then we'll factor in what the tax debt is going to be. But if you're retaining an asset and you might sell it in 1, 5, 10 years' time, well, ultimately that capital gains that you're going to have to pay is your problem, and it doesn't get taken into account and deducted from the asset pool. So it's always prudent to get advice about what the current tax implications are of whatever you're retaining as part of an asset pool, and also what the down the track implications might be.
Yes, another client some time ago almost had a heart attack when I said to them there might be some capital gains tax implications upon splitting up with their spouse. But there's a lot of things to take into consideration. For example, was that house ever a principal place of residence? If it was a principal place of residence for less than if it was a principal residence for a given period and they've moved out of that house, it became a investment property, but they had no other principal place of residence and no other asset, no other house under their name, then that house, their principal place of residence, can continue to be deemed as their principal place of residence for up to 6 years. So although it was rented out for some time, you can say, we can look at it, see exactly what's happening, and we can deem it to have the 6-year absence rule apply, and for that property to continue to be their principal place of residence. So as you can imagine, that's a huge sigh of relief. I am 100% with you in terms of the relationship rollover exemption, where the relationship is no longer there, it's fallen apart, and the capital gains tax can be rolled over. So the party who's transferring the asset applies that exemption, so there's no capital gains tax there. But the other party in the agreement needs to factor in the tax that they're going to pay when they eventually dispose of that property. And sometimes what they end up doing is they say, okay, what is the market value at the moment? Even if I'm holding the asset, what is the market value? So let's calculate the capital gains on that basis and split up the capital gains between us. So they're very, very important parts. Other things that people should bear in mind is that the capital gains tax rollover on relationship breakdown applies when you transfer an asset from yourself as an individual to your spouse as an individual. If you're going to transfer it to a trust or a company, it doesn't apply. And there's court cases that prove exactly just that, and that's how the courts have interpreted. So it's very important, again, with these things, that you are speaking to the right professionals and you're getting the right advice. So you're creating win-win situations and you are doing things amicably and making sure you're on top of it so you're not missing out. I think we pretty much covered everything. Jane, do you want to add anything to that last point there?
No, I was nodding furiously because that's exactly what I was going to say. And I know we touched on that between us before about it depends on what the entities are and whether it's individuals or not. And I guess the bottom line with all of this conversation that we've just had is, as you said, people can see how massively complex it is from a family law perspective, but also from an accounting perspective. So the bottom line is always advice, advice, advice.
Yeah. The other thing I wanted to ask you just on that, the tax implications of things, if a party is looking to say pay the loan out on the property on the transfer, is that considered consideration and therefore capital gains tax would apply, or because it's part of a binding financial agreement, the rollover would still apply?
Can you say some more about what you mean there?
Yeah, that's probably a little bit more technical and something we could potentially look at down the track, maybe do another session looking at other aspects of family law, which we haven't covered today. And if anyone wants to make any comments, ask other questions, by all means, please do so. And we can definitely look at having another session. So to go to that, if someone is transferring a property to their spouse in exchange,
it's been owned by individuals.
Yep, owned by individuals. Yep. So two parties, Mr. Smith and Mrs. Smith, right? We're going to say Mrs. Smith transferred the asset to Mr. Smith. Mr. Smith ends up paying the loan, the remaining loan for that property.
Right. So Mr. Smith, who is receiving the property, pays out the mortgage for the property.
Yes.
Yep.
Under the binding financial agreement, would the marriage rollover breakdown still apply, or is it deemed there is a consideration being paid in relation to that property and therefore there is capital gains tax?
This sounds more like a you question than a me question, I reckon. But it's not a fact. All I can say is it's not a factor that I've seen attract capital gains as an issue.
Yes.
Because it's still, and I would have thought logically, because you're still dealing with a transaction that's, particularly if it's been a principal place of residence, you're still dealing with a transaction that's between spouses as individuals to a marriage. So I would have thought that that would still attract the rollover provisions, don't you reckon?
I would say yes, it would. But it's definitely something I want to look at in my own time, or I'll reach out to you and we can look at it together.
Such a nuanced area for both of us, right?
Correct. And that just goes to show the importance of speaking again to the right people, but also understanding that every area is unique. And we need to look at it and we actually go back to the law and say, what does the law say? What does case law say? Not just legislation, but what does case law say?
Absolutely.
And then ensure that we're interpreting and applying things correctly. Do you have any other comments for us? Any tips or tricks you'd like to share with us before we conclude today?
I think really that we have covered the main areas. I guess that in summary, things to think about when you're entering into a relationship is, do you want to protect your assets in the event that you separate? And when you are separating, the aspects that you're going to be dealing with are, one, importantly, how much time are the kids going to spend with each of us? How are we going to survive financially? Is there going to be spousal maintenance or child support that's payable? And how are we going to disentangle our empire? How are we going to divide our assets? Those are the big picture things that need to be considered. And all of those things need advice from the relevant experts. Here's
a question for you before we finish off. How long should people potentially date each other or get to know each other before they get married to so they know this is the right decision?
Some people know that in 5 minutes, don't they? And some people take years and still get it wrong.
Yeah.
But if in doubt and if you've got assets to protect, get a cohab agreement.
Yeah. Look at the recent example we had, Queen Mary Mary and Prince Philip.
Absolutely.
They married, apparently, Prince Frederick, my apologies. They met in a bar, apparently.
Totally they did. And look at that. Literally a royal fairy tale ending.
Exactly. May we all have royal fairy tale endings. Thank you very much for your time. I appreciate your expertise and we look forward to having you on another session.
Thanks, Minna.
Feel free to reach out to us time to the viewers and ask either Jane or myself any questions. We will put our contact details up so you can reach us. And by all means, provide any comments, anything else that you want us to cover in the next session, please let us know. For now, thank you all very, very much and have an amazing day. Thanks, Jane, again.
Thanks, everyone. Thanks, Minna.
Yeah.